Hello everyone, this is Shiv Prem, a legal intern at LEXIS and Company and currently pursuing BLLB honors from Central University of South Bihar. So in the today's session, I will be dealing with the charge. What is the purpose of charge? What are the types of cases where charges are framed? Further, we are going through the contents of charge, and this topic will also be covered in two parts. In the first part, I will be dealing with these parts and these topics, these subtopics, and further in the second part, I will be going through the topics when when court can alter or amend a charge, or basic rules as to charge and trial of charge, and there further there are some exceptions which we'll see. So let us start from the introduction part of charge, like as Section 2 Clause B of the CRPC, that is Criminal Procedure Code, defines charge as any head of a charge when the charge contains more heads than one. Under Section 2 Clause B, charge includes any head of charge when the charge contains more heads than one. Hence, it can be interpreted that when a charge contains more than one head, the head of charges is likewise a charge. The legal definition mentioned in the code is not inclusive enough for a layman to decipher. However, the definition could simply be interpreted to mean as an accusation. It is the concrete accusations as recognized by the magistrate or the court based on the prima facie evidence adduced against the accused. Let us see what is the purpose of charge. Every charge under the Code of Criminal Procedure shall state the offence with which the accused is charged. The motive behind a charge is precisely and succinctly to let the accused individual know for the issue for which he is being charged. It is necessary to pass on the accused absolutely clearly and with certainty what the prosecution has the accused him of, or what the prosecution has against him. The underlying principle of criminal law is based on the fact that it is the right of the accused to be informed about the exact number of the charge leveled against him. The charge which is levied against the accused is important for him to be known so that he can prepare his defense and so that justice is done by him. It is in the very beginning, or that the accused is informed of his accusations in the beginning itself. It is to be kept in mind that in case of serious offences, the statute requires the accusations to be formulated and reduced to writing with great precision and clarity. It is also necessary that the charge be then read and explained to the accused person with the precision and clarity. Now let us see what are the types of charge and where charges are framed. The question of framing a charge against the accused arises only when the accused is not entitled to a discharge under Section 277 and 239 of the CRPC. 277 deals with the discharge of the accused in sessions cases, and Section 239 of the Code deals with the discharge of accused in warrant cases. There are further types of cases where the charged are framed under the Criminal Procedure Code, like session cases under Section 228 of the Code, then warrant cases instituted on the police reports under Section 240 of the Code. Further, the warrant cases instituted otherwise on police report under Section 246 Clause 1 of the Code. Now let us see what are the contents of charge. The initial requirement under the Code for a free and fair trial is to inform the accused precisely and accurately of the offence he is charged with, so as to give him a fair opportunity to prepare his defense. Section 211 and Section 212 of the Code prescribes the forms and contents of the charge. However, when the nature of the case is such that the offence in question cannot be described properly by the particulars as mentioned in the aforesaid sections. So as to give accused sufficient notice of the offence with which he is charged, then the manner in which the offence was committed by the accused shall also be contained in the particulars of the charge. This shall be considered sufficient for the purpose of providing sufficient notice to the accused of the offence with which he is charged. According to section 211 of the CRPC, every charge under the code shall include the following, like the offence with which the accused is charged. Any law gives the offence any specific name, then the description of that charge by that name only. Further, the definition of the offence under the law that does not give any specific name to the offence so as to give notice of the matter to the accused of which he is charged. Further, then the law and the section of the law against which the offence is said to have been committed. Let us see what are the particulars as to time, like place and person. According to section 212 of the code, in order to give sufficient notice of the matter to the accused of which he is charged, then the charge shall contain the following components, like time and place of the alleged places, the person, if any, against whom the offence was committed, the thing, if any, in respect of which the offence was committed by the accused. It should be noted that in case of offence is committed which is of the nature of criminal breach of trust or dishonest misappropriation, when the exact amount in question cannot be determined, then in the said charge it shall be sufficient to specify the gross sum of the money or movable property as the case may be, in respect of which the offence was committed. In addition, the dates between which the said offence was committed shall also be mentioned in the charge sheet. It shall also be noted that it shall not be necessary to specify the exact items in question or the exact dates, provided that the time included between the first and the last date of the such date does not exceed 1 year. That's all for now. Let us meet in the other session where I will be discussing about the basic rules of trial and trial of charge and some exceptions and some other points. That's all for now. Please do like and subscribe the channel. Thank you.